All right, who's here on Jacob? I'm sorry, Joshua Jacob Cannon? Yes. Hello.
Good morning, Your Honor.
Morning.
Jason, your hand's working on it.
Okay. Hello.
I mean, it looks like You put him on the left or the right, Judge?
Oh, no, he's in the center. You're on this side. All right, so are you all proceeding on the motion to revoke?
We had the recommendation that MRT, this is going to go forward. Yes, that's the MRT and the ILP.
All right, the court is calling 2023 CR 2570B State versus Joshua Jacob Cannon. Can I have parties announced for the record?
Jason, Your Honor.
Mark Lift for fence, Judge.
And are you Joshua Jacob Cannon?
Sure.
All right, so here's the thing. You got to save the tears because we're here on a motion to revoke because the state is alleging that there are some actions that you did that were a violation of your conditions. Do you understand? All right. So are you the same Joshua Jacob Cannon who was placed on deferred adjudication in 2023 CR 2570B for the offense of aggravated robbery on June 12, 2023 for a period of 10 years? Is that you?
Yes, Your Honor.
All right, state.
Yes, Your Honor. And we're proceeding with number 2. That is the second to last number 2.
Okay.
There's a violation of condition number 2 on or about the 16th day of August 2024. Bear County says the defendant Joshua Jacob Cannon and then there commits to the illegal use of controlled substance, namely marijuana, violation of condition number 2.
How do you plead to that? True or not true?
True.
Waiver name violating condition.
Any objections?
No objection, Your Honor.
Did you understand by pleading true to violation of condition number 2, the court could find it true, grant the motion, find you guilty, and sentence you to life in prison?
Yes, sir.
Do you understand if you have some sort of an agreement that you've worked out with the state, I don't have to follow that. Once you've pled true, I can sentence you to life in prison. Do you understand that?
I understand.
Knowing that you still wish to plead true to violation of condition number 2?
Yes.
Court is finding violation of condition number 2 true. Is there a proposed agreement?
There is, Your Honor. It is denied a motion to adjudicate, continue the individual on the deferred with the amendments to add MRT killers and intensive outpatient treatment.
All right, is that the proposed agreement?
It is, Your Honor.
All right, let me ask you something. Do you want to go to prison?
No, ma'am.
Then why are you doing this?
Bad decisions.
No, I mean, here's the thing. You have decisions that you have to make. And on the one hand, your decision is, do I want to do this? If I do this and I'm caught, I could look at life in prison. And then what ends up happening is your attorney has and this is where I've been a defense attorney before. This is where the attorneys are throwing themselves on the mercy of the court saying, please let this judge follow our agreement, even though I don't have to do it. So when you're making decisions and knowing you could go to prison and you're still choosing to do this nonsense.
I've been going to NA meetings. I've been going there for 2 weeks.
Mhm.
So I've been trying to.
Well, but see, here's the thing. You've been on probation since 2023 and you only have two weeks. What have you been doing with your life? Do you have employment?
Yes.
What do you do?
I work for Hill Country Waste Solutions. I've worked 60 hours every week.
Mm-hmm. But you find time to do this. So, I mean, I will tell you, and your attorney will tell you, and Mr. Garhan will tell you. How old are you?
20.
You're 20. Do you know how many 20-year-olds are at the prison? A lot. And if you don't want to get your life in order, you know what's going to end up happening? You're going to be at the prison. I will still remember you because I remember all the people who come through here. But you know what everybody's going to say? Oh, well. And this is what I can tell you about the government. The government may not have money to build state hospitals, but they will always find money for the prisons. And whether or not there's supposed to be 5 people in the cell or 2 people in the cell, they will put 5 people in that cell. They will put 6 people in that cell because they're not going to let you just be out here and say, oh, well, it's overcrowded, so we don't have another jail, so we'll just let him be out here. That's not the way it works. And he can tell you that's not the way it works. And if you're drug tested today, are you going to be positive? You need to tell the truth and shame the devil. What are you going to be positive for?
Marijuana.
Yeah.
So here's the thing. I know people say marijuana is not a big thing, but when you're on probation, guess what? And your attorney will tell you this. You're not even allowed to drink alcohol in your house.
Yes, ma'am.
So you're not even allowed to smoke marijuana in your house. If you do, you know what that's telling me? You want to go to prison. So I'm going to give you a decision. And what I can tell you is, you know yourself better than your attorney does, better than I do, better than probation, better than the state does. So I want you to look deep inside yourself and discover and realize whether or not you can complete this probation or not, because you signed up for probation to be on probation for 10 years. So that's 2033. If you cannot complete this probation and you know you cannot complete this probation, just let us know. I will sentence you to 5 years in the prison. Otherwise, I will follow this agreement that you've reached. They're going to give you UAs and they're going to test for levels. If those levels go up, that signifies that you're using, and a motion to revoke is going to be filed, and we're going to be right back here. So those are your only 2 choices. I'll give you the MRT, the intensive outpatient treatment. I'm going to make you do NA meetings, and they're going to test for levels, or you can call it a day, and I'll sentence you to 5 years in the prison. Which do you prefer?
TR meetings.
Have you had a time to internalize that?
Yes, ma'am.
All right, because I will tell you, the state will tell you, I've sent 20-year-olds to prison before.
And Judge, I know he's very emotional right now, but when I've talked with him, he has conveyed he needs help. I mean, he has been self-medicating. He got in a real bad accident about 1.5 years ago, jacked up his hip, no excuse, but he needs help to figure out not doing that. I mean, he takes full responsibility, Judge.
All right, probation, I'll deny the and I'm sorry, probation, are you recommending this as well?
Yes, Judge.
All right, the court will deny the motion, alternate amending conditions to include the MRT, IOP, and I'm going to want UAs, test him for levels. And he's going to do sober support meetings. In 30 days. And your levels should start going down. Do you understand?
Yes, ma'am.
Is there anything else you need from the court to be successful?
No.
Judge Austin, do you want to give that as way?
How often are you, because it's marijuana in his system?
Every 2 weeks, Judge.
All right, so there's going to be UA every 2 weeks until he presents with a negative UA. Is there anything else you need from the court to be successful? All right, we can go off the record. Here's the thing. Everything that you do from here on out, I'm going to help you with your decision making. If your actions could result in you being revoked and going to prison, you shouldn't do it. If your actions are like, maybe this is something I can get revoked for, maybe not, you shouldn't do it. Do you understand? Because otherwise, you're going to be at the prison. And either you are, well, first a motion to revoke will be filed. Either you're going to make bond or you're not. If you don't make bond, we'll bring you over dressed in orange. We'll hear it. And either you're going to get revoked or not. And either you'll end up in prison or not. Do you understand?
Yes, ma'am.
All right. Good luck to you.
Thank you, Your Honor.
You're welcome. All right. Anyone else ready?
Yeah, just on page 2, second one. This is
All right. Jesse Lutzenberger. And where's the other attorney? He said he had a plea. Oh, he's going over paperwork? So this is a plea bargain agreement. The court is calling 2025 CR 003-507 State versus Jesse Lutzenberger. Can I have parties announce?
John Whalen for Jesse Lutzenberger.
All right, excuse me, in the box. You all need to lower your voices. And are you Jesse Lutzenberger?
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
We have, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Lutzenberger, did you review the application for deferred adjudication with your attorney? Did you understand it and sign it?
Yep.
That's either yes or no.
Yes.
All right. Did you review the true bill of indictment with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
The seeing on the proceedings, it's all from the entry.
Any objections?
No objections, Your Honor.
Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
To your,
No. Did you review this document? Did you understand it?
Yeah.
Did you sign it in all the appropriate places?
yes, ma'am.
The state is proceeding on the lesser included offense of assault bodily injury as a Class A misdemeanor. The range of punishment is anywhere from a $4,000 fine and up to 1 year in the Bexar County Jail. Did you understand?
Yes.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 1 year in the Bexar County Jail and up to a $4,000 fine? Did you understand?
Yes.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do, Your Honor.
Mr. Lutzenberger, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes.
If you're not a U.S. citizen, by entering this plea, you will be deported and denied naturalization and denied re-entry into the United States. Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes.
According to the plea, the state is proceeding on the lesser included offense of assault bodily injury. There's a $500 fine and the state recommends deferred adjudication. Did you understand that to be the plea?
Yes.
Defense?
Yes, Your Honor.
State?
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yeah.
That's either yes or no.
Yes.
Counsel, have there been any such motions?
No, Your Honor.
Outside the agreement, the state is requesting that your community supervision be for a term of 2 years. There'll be a TAP evaluation, 200 hours community service restitution, no contact with Mario Montemayor, and the hostility management course. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the lesser included offense, how do you plead? Guilty, not guilty, or no contest?
No kind.
State, any evidence?
In other states,
No objections, Your Honor.
All right, and state, have you had a chance to speak with the complainant?
yes,
All right, thank you. You may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. After reviewing state's exhibits and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
We are, yeah.
Anything you wish to say on behalf of your client?
Just that we wish that you follow the agreement, Your Honor.
All right, what were your issues that day?
Were my issues that day?
Yes.
Well, I couldn't believe it was happening because all I wanted to do was go vote.
No, the problem was not you going to vote. And I will tell you, I teach campaign and election law. And when people at a location tell you that you're not allowed to wear certain items when you go into the voting booth, you're not allowed to do that. When they tell you you're not allowed to wear certain items when you're entering doors, you're not allowed to do that.
They told that it wasn't posted anywhere, and the people that were working there didn't know themselves.
No,
They
that's
would
the
have
law.
told me that.
I'm telling you, that's the
Well,
law.
I'm telling you, I didn't know, and other people didn't know.
Well-
I'm explaining my situation. That doesn't seem that anybody's heard yet.
Oh, well, let me just tell you what it says in here in the police report, because maybe you didn't read it. It says you were walking in and the person, they have judges who are there for voting and they have people who are working there,
Mhm.
who work there. It's yes or no. It's not, They were working there and they told you you needed to remove your hat because it was not allowed inside the voting area. And that's the law. And that's always, but here's the thing. That's the law. It's always been the law. For example, I can't walk around with a t-shirt with my name on it saying vote for me and go in the voting booth. It's not allowed. Once you get to a certain point and it's that 100-yard line that they have, when you cross into that area, you're not allowed to be in line with t-shirts about who you support. You're not allowed to do that.
Yeah.
That's the law.
I
And
understand
then when people tell you that, you can't start hitting somebody. And it says on here that your wife even tried to stop you.
Ma'am, that's all incorrect. Do you want me to explain? Can I explain?
Sure. And if you want a jury trial, I'll give you one.
Well, I'm not talking to you, I just want to explain because it's incorrect what they're saying. I was in line for 45 minutes before I actually got to vote. They asked me to remove my hat then, after I was standing there for 45 minutes. So I removed it, I put it in my lower back. I went through the whole voting situation. When I went out the other side, this person that had already harassed me in 2 other previous times that I went to go vote in a different location was again there. I walked away from him twice, 2 other times when he was verbally harassing me. Okay, this is the 3rd time. And this 3rd time, I walked away from him again twice. He would not let me walk out of that place without harassing me and getting physical with me.
All right. So
That's what my wife was trying to.
let me tell you what it says in here. And I go by this document. It says that the complainant went on by explaining that as part of his duties, he is supposed to advise voters that they are not permitted to wear or display candidates on their person while they are on the polling premises. It says he observed an older adult male inside the polling premises and you had displayed campaign material, which was your hat. He observed the violation. He contacted the male and advised him that he would need to refrain from wearing the hat while on the premises. The complainant explained that the male complied with his instructions while he was voting, but then put the hat back on as he was making his way to exit the premises. At the time, the male was still inside the building and clearly well within the premises. Due to still being well within the premises, he approached you again and advised you to remove the hat while he was on the premises. The male, that's you, explained that he was on his way out and refused to comply. And it says, he began to follow you and told you again to remove your hat. And as you were about to exit, you struck him on the chest and facial area several times with your fist, causing him pain and discomfort. And then it says, another witness and your wife began telling you to stop. And then that's when you left. I don't know why when people go to places, how hard it is to follow instructions. When they say you can't do something, you can't do it. And if you want to complain about it, complain to your legislature. If you want to wear campaign materials inside a location while you're voting, if you want to wear it within the 100 lines, because they have those lines marked with a white, sometimes yellow line. If you want to do that, then you need to write your legislator and say, look, you need to change these rules because I want to wear my campaign gear inside the area while I'm voting. But for now, you're not allowed to do that. And you need to follow the rules. How old are you?
Or
All right, you're 64 and you're up here fighting at and I don't even call it fighting because it doesn't say that he ever even hit you back.
yeah, of course.
And so you're up here fighting with somebody who's just trying to do their job, help people come in and vote and go on your merry way. And they're not even paid enough money for somebody to be hitting on them. So it appears to me you do have anger issues.
No, I don't have any. Like I said, I walked away twice, and in the situation I walked away twice. Did say anything in there where he followed me all the way and he screamed in my ear? I have hearing difficulties from my time in the military. I didn't hear what he was saying. I was walking out, and he was quite a ways.
Did he not tell you to remove your campaign gear
No,
and that you were not allowed
That was-
in the area?
that was after the fact when I had already gone out. I was in the library section already.
Let me just tell you, within that 100 line, you are not allowed to wear campaign gear. Now, if you're saying what's being said is untrue, then you need to set this for a jury trial because I go specifically by what's in the police reports. And there's a reason why this says waiver consent to stipulation of testimony and stipulations. You know what that means? That means that everything is in this document. You're stipulating that it is true and correct. And this is what it says. I, Jesse Lutzenberger, do hereby judicially confess and admit that I intentionally and knowingly in Bexar County, Texas, on or about the 24th of October, 2024, did intentionally and knowing cause injury to the complainant by striking the complainant with the hand of the defendant and by pushing the complainant with the hand of the defendant. That's, you stipulated to that and said it's true.
Anything about him punching at me first?
What I'm telling you is you're saying this is true. You stipulated to this. Now, if you're saying he punched you first, then maybe you want a jury trial and you want to say it's self-defense.
It's on video. The only reason why I'm accepting that because I don't have the money to continue. Or of course I would defend myself.
All right, does he
That's
want a
fine,
jury
keep
trial?
going. No, we're accepting the plea.
Is your wife, is somebody here?
My wife is here.
Oh, she said, no, you don't want a jury trial.
Okay, no.
All right.
Your Honor, if I may, I believe that, look, point being there's, as you stated, that's completely clear. The law is the law. I think that there was a fundamental miscommunication and understanding as far as how it was proffered to him at that time. I think that realistically, the way people speak, someone told him, take off the hat while you're voting. I think in his head, that's what he believed. Hey, take the hat off. I'm walking out the door. I'm basically at the double doors. I can put the hat back on. Understanding clearly that is still in violation of the law. But I want to make clear, it's not like the statute book was not pulled out and read to him at this time to understand the 100 feet. Again, it's not an excuse, but I think where his mind was coming at, he had finished voting, he had waited the 45 minutes, and he was leaving, and then he had an individual come up and approach him. Just to give some context, it's not change, obviously, the law itself or your viewpoint of this, but I want to...
Well, I mean, my viewpoint is the stipulations that I received.
Understood.
All right. There's going to be a $500 fine, 2 years deferred adjudication, 200 hours of community service restitution, proof of employment within 30 days, no employment as a home health care provider or with minors. There's going to be the hostility management course, regular reporting by Zoom or in person, regular random UAs, field visits 1 time per month for 6 months. And there's to be no contact with Mario Montemayor. Probation, is there anything else?
Judge.
Is there anything else you need from the court to be successful?
No, I would like to say that all this is my self-defense. Because nobody wants to be harassed or bullied in front of their significant other.
Yeah. I understand. You know what? I understand here's the thing. I understand what you're saying. And I understand sometimes that tempers run high, right? And sometimes when we don't know the law, and if somebody just tells you, you can't do that, sometimes people want to know why I can't do that. And they want you to explain it. Sometimes people will explain it. Sometimes they will not. For example, I try to explain everything so people will know why things are happening. So now you know, and I'm telling you, yeah. So here's the thing. This is what I'm telling you. When you see, if you go vote again, when you see that line, you are not to cross that line with any campaign materials. And that's why when you see candidates who are out there talking to people, they're not allowed to go past that line. You know why? Because you are not allowed to campaign past that line. And wearing T-shirts or any type of hats or anything for whatever candidate you support, whether you say anything or not, that's considered campaigning. And legally, you're not allowed to do that. And if people want to change the law where they can wear their campaign shirts or whatever beyond that line, you have to do that with your legislator. My job is just to follow the law. You understand?
Mm-hmm. Yes. This happened in Georgia and it happened in South Carolina, I think. And the people still got to go and went on their ways.
Well,
Different ways, right?
This is Texas.
Yep.
All right. Did you review the document entitled Trial Court Certification of Defendants' Rights to Appeal with your attorney? Did you understand it and sign it?
Yes.
All right. Because this is plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
All right. Ms. Abrams will speak to you.
Okay.
All right. Thank you.
Thank you, Your Honor.
You're welcome. Christy Riojos. Come up, Christy Riojos. Court is calling 2025 CR 008178 State versus Christy Emilio Riojos. Could I have parties announced?
Robert Brabant for Riojos.
And are you Miss Riojos?
Yes, ma'am.
I'm so sorry about mispronouncing your name. You can lower your hand. Counsel, you received all discovery.
Yes, ma'am. I have.
Did you review it with your client?
Yes, I did.
Court will find that the state is in compliance with discovery. Are there any applications in this case?
No application, Joe.
Ms. Riojos, did you review the true bill of indictment with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
Yes, ma'am.
State, are you proceeding on the indictment as presented?
Yes.
Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
You're charged with possession of a controlled substance, penalty group 1, less than 1 gram. That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand? You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter a plea in this case? Counsel, has your client have been able to provide you with any defenses?
Yes, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
Yes, I do.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, she's mentally competent. Yeah.
Ms. Riojos, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Anyone promise you anything other than the plea? Are you satisfied with the way you've been represented? If you're not a U.S. citizen, by entering this plea, you will be deported, not allowed re-entry, and denied naturalization. Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney, and did you understand it? According to the plea, punishment is to be assessed at 96 days in the Bear County Jail under 1244, and there's $1,000 fine and no applications. Did you understand that to be the plea? Defense, is that the plea?
Yes, ma'am, it is.
State, is that the plea?
It is.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, yeah.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest? State, any evidence to support the defendant's plea?
Stenographer states one and attached.
No objection, Your Honor.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. State, you may be excused. Thank you. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will find you guilty. Are you proceeding with sentencing?
Yes, we are, Your Honor.
Anything you wish to say on behalf of your client?
No, just to follow the plea agreement.
All right, the court will follow your agreement, sentence you to $1,000 fine. Time and money will run concurrently. The court will sentence you to 96 days in the Bear County Jail under 1244 and give you credit for any time served. Did you review the document entitled Trial Court Certification of Defendants' Rights to Appeal with your attorney? Did you understand it and sign it?
Yes.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. Here's the thing. Obviously, you have a drug problem, right? When you're released from custody, if you cannot find a sober living place or you need some help finding a place to go, if I'm still here, you come back here, I will pick up the phone and call somebody to help you. You understand? Because if you continue like you are, only one or two things going to happen. Either you're going to be in and out of jail, in and out of prison, or somebody may end up having to identify your body because the last time you use may be the last time you use. You understand? All right. Good luck to you. Thank you,
Thank you,
counsel.
Judge.
Who's next?
Good day.
Donna Ellis.
Juan Lopez.
Court is calling 2023 CR 3770 State versus Donna Lynn Ellis. Can I have parties announced?
Lawrence notes for the state.
Peter Calderola standing in for Gail Calderola for Miss Ellis, Your Honor.
All right. Do you have any objection to this attorney standing in?
No, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Ms. Ellis, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, sir.
Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
You're charged with evading arrest, detention with a vehicle. That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in the prison and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
She has, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
I do so believe, Judge.
Do you believe she is currently competent and was legally sane at the time of the offense?
Yes, Your Honor, I believe she was.
Ms. Ellis, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and denied reentry into the United States. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 2 years in the prison. There's an $800 fine. There are no applications. The state will take in consideration CC 701359. Did you understand that to be the plea?
Yes, ma'am.
Defense, is that the plea?
It is, Your Honor.
State, is that the plea?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
None that I'm aware of, Judge.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
Yes, Your Honor, state offers states exhibit 1 and all attachments.
No objections, Your Honor.
All right, state, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. What is happening with the drug?
I believe which case, Judge? Are you
Well,
referring to?
in the police report, they say that she had drugs.
That was rejected, Your Honor, back on 5/2 of 2023 when our office received notice.
Right. All right, is there anything else you wish to say on behalf of your client?
Yes, Judge. I understand that my client, I believe, has 128 days credit here in Bear County. However, she's been in custody since the inception of this case. She was sentenced to TDC out of a different county, and that sentence occurred, I believe, in December of 2023. So my client has roughly about a year and 10 months of time at TDC. So we're asking the court, respectfully requesting the court satisfy this judgment today.
All right, then she'll receive, well, I'm not going to judgment satisfied, but what I will tell you is you'll receive custody for any time that you've been in custody while this case has been pending. All right, so if you were in custody and this case was still pending, I'll give you credit for that.
Okay.
All right. So do you know which TDC case number that is?
I do not have the TDC case number. My client does have that information in her jail cell.
So what we can do is just, your counsel will call the court and he'll let us know which case number it is, and I'll have it run concurrently with that, and you'll receive credit for that.
Yes, ma'am.
All right.
Thank you.
All right. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right. Normally, Ms. Ellis, I will recommend the therapeutic community for people who want it, but it appeared in the police report that you said you did not want to stop using. So do you want me to recommend the therapeutic community for you? It doesn't increase the time that you're in custody, but it's to help you with any other issues you may be experiencing.
While I was in TDC, I completed a 120-day NTC program, drug rehabilitation
Okay,
program.
that is awesome.
Also anger management, and I got extra college credits. I was also a teaching assistant for GED to my other peers.
Mhm.
I completed a Christian 12-step program.
Mhm.
So I wasn't just sitting there idly by.
All right. So has that been helping you?
It has.
All right. So this is what I'm going to tell you, what I've noticed, and I don't want you to fall into this trap. Usually when people get out of prison, they celebrate and it goes downhill from there. So when you're released from prison, if you cannot find a sober living house or someplace to help you, if I'm still here, you come back here, I'll pick up the phone and call somebody to help you.
Yes, ma'am. I
All
do
right.
have a place to go.
Oh, that is so awesome. All right. Well, good luck to you.
Thank you very much.
All right. Thank you.
Thank you, Your Honor. May we excuse?
Yes.